One of the easiest ways to really understand the law is to look at cases where it's actually been applied. In fact, that's how they teach us in law school. And so today I want to talk about favoritism and retaliation because I was recently presented with facts and a question as to whether or not the person had a case based on favoritism and retaliation. But before I get into it, I want to ask you to please hit like and subscribe if you like my content, because that's how I am, afforded the opportunity to continue bringing you more of the same. It helps a whole lot. So I'd appreciate it. Like and subscribe. So let's get into it. Here's the reality. Not everything that feels unfair at work is unlawful. So let me explain to you why I could not take a case that I was recently presented with taking based on favoritism and retaliation. So someone reached out to me after getting fired. He was devastated, fired without warning, no clear reason given, except it's not working out. Peace out. Now, he said his supervisor didn't like him because he wouldn't kiss up. He said the supervisor didn't know what she was doing, and worse, the supervisor was best friends with the owner of the company. Now, according to this person, the supervisor's lack of knowledge really made his job a lot more difficult. The supervisor not knowing what the supervisor was doing meant that he had to do extra work and just really made his job unnecessarily difficult. So the employee went around the supervisor and complained directly to the owner. The owner told the employee, "We'll look into it." And a few weeks later, the next thing you know, he's fired. No reason given, just fired. Now, my question to the employee was, why do you believe you were fired? Now, this is a question that I ask all prospective clients because litigation is tough. I mean, you will be forced to sit under oath, take what we call a deposition, for 7 hours while the attorney for the company that you sued questions you about every little thing about your case, including what you believe to be the reason for your termination. And if you are not telling the truth, or if you're making up something just to file a lawsuit, it will come out. And so, of course, I can take what you're saying and dress it up and make it a legal claim, but I need to know that you really believe that that's really what you think, because I know it's going to come out in the end. So I asked the employee, former employee, why do you believe you were fired? And his answer was, because I wouldn't kiss up and because of plain old favoritism. Now, I had already gathered, based on everything I was hearing, that there was no case there. The truth is, and this is a hard truth, favoritism is not illegal, especially not in this circumstance, under these circumstances. And kissing up is not protected activity, or refusing to kiss up. It's not protected activity. And a supervisor making your job harder is not unlawful conduct. It just simply isn't. It can become unlawful if, for example, the favoritism is tied to a protected class. You always have to have that present. So if the favoritism was, I was gonna keep you, but we want younger people anyway, and we're trying to get rid of the old heads, and so we're going to let you go. And my friend, who happens to be your supervisor, says that they've got lots of younger people applying, and so now's as good a time as any to get rid of you. Well, that's age discrimination. That's linked to favoritism, sort of, but you get my point. In order for favoritism to be unlawful, it still has to relate back to one of those protected classes. And in this case, I wasn't hearing any of that. So my next question was, have you been to the EEOC? Because in almost every instance, you have to file a claim with the EEOC, a charge of discrimination with the EEOC, before you can sue your employer. Very few exceptions to that rule. And so I was curious as to what the employee represented to the EEOC, because from what I was hearing, I wasn't hearing a case. And interestingly, he said, I tried to file a charge with the EEOC, but there was no box for me to check. There was no box for retaliation. And I said, okay. And I said, so why do you believe you had a retaliation claim? And he said, because I was retaliated against. I got fired after complaining. And so here is where people get really confused. It's not just any complaint. It's not my boss is micromanages me and I complained about the micromanagement and the next thing you know, I was terminated. Or my boss is just too hands-on and I complained about my boss being too hands-on. Next thing you know, I was fired. It has to be that you complained about illegal conduct, because the law wants to dissuade companies from firing people when they speak out about rights that they have. So if you engage in activity, what they call protected activity, such as speaking out against racism, speaking out against sexism, speaking out against harassment based on your age, race, sex, gender, disability, when you do that, you are engaging in lawful conduct. And if they come back and take action against you for doing that, then that is retaliation under the law. So I asked again, what was the retaliation based on? And he says, favoritism. And I said, but favoritism in and of itself is not illegal. You haven't told me anything that would tie it to your age, race, sex, gender, disability. And he said, because I don't think that that's true. And I said, yeah, I'm gathering that because I haven't heard you say anything. I try to let clients talk instead of me interjecting and saying, well, was it this or was it that? Was it that? I want to hear what you have to say because like I said, it's going to come out. So none of that was present. And I said, there's just, unfortunately nothing I can do to help you because you have not stated a claim. So, again, retaliation is illegal. It is a claim standing on its own, but it has to tie back to something protected: race, gender, age, disability. If you didn't complain about discrimination or harassment based on one of those protected classes, it's not retaliation under the law. At the end of the day, you can feel wronged, you can feel targeted, but unless it's tied to protected activity, conduct is not unlawful and you don't have a legal claim. And the other thing I want to say, and this is not dealing with law, this is more kind of a common sense thing, and that is read the room. If you know the supervisor and the owner are tight, and your only complaint is that your supervisor doesn't know what she's doing and making your life difficult, think about who you're talking to. Read the room, especially if you are not absolutely 100% certain that you'll have a claim in the event that the owner of the company or the supervisor takes action against you after you complain. I mean, at a minimum, talk to a lawyer first because you might find yourself out in the cold. And let me tell you, the way the job market is right now, the jobs report is just horrible. It was already difficult for employees even before that, but now where jobs are scarce, it's just, it pays to read the room. I'll see you next shift.